So welcome everybody as you're joining in. Thank you so much for joining us today. For those of you who do not know me, my name is Elizabeth Hosier, and I am the Director of Programs at the Robert H. Jackson Center here in Jamestown, New York. The Jackson Center envisions a world where the universal principles of justice, fairness, and equality prevail. We are excited to continue our symposium, Nuremberg at 80, an International Reflection today. A few housekeeping notes: the automated captions are enabled, so if you need those, please turn on that feature to enhance your experience. There will be a Q&A portion at the end of our conversation today, but don't feel like you need to wait to ask your questions. You can drop them in the Q&A or in the chat as you think of them. Okay, in the summer of 1945, the world stood at a crossroads. The war in Europe had ended, the extent of the Nazi crimes was coming into full view, and the Allied powers faced a fundamental question. How should world history's worst atrocities be answered? The easy path was retribution. The harder and more consequential path was justice under law. At that moment, President Harry S. Truman made a defining choice. He turned to a sitting justice of the United States Supreme Court, Robert H. Jackson, and asked him to leave the bench and travel to Europe to prosecute the architects of the Nazi regime. It was an extraordinary appointment, one that placed an American justice and the legal principles at the center of a global reckoning. Jackson understood what was at stake. At Nuremberg, he was not simply prosecuting defeated enemies, but he was helping to establish a precedent for the future. He famously warned of the record on which these defendants were judged was also the record on which history would judge us. The trials, Jackson believed, had to be fair, restrained, and rooted in law, or they would mean nothing at all. Today's program explores the moment of decision and partnership, Truman's resolve to pursue justice rather than vengeance, and Jackson's leadership in transforming that resolve into legal framework that still shapes international law and human rights today. We are honored to welcome Dr. Randy Sowell, Archivist at the Harry S. Truman Presidential Library and Museum. Drawing on original documents and materials from the Truman Library, Randy will examine Truman's thinking behind appointing Jackson, the support he provided, and how this collaboration helped shape the Nuremberg Trials. Following the presentation, again, we'll have time for questions and discussion. So thank you for being here and for engaging with this enduring legacy. Please join me in welcoming Dr. Sowell. You can take it away, Randy.
All right, thank you. I hope you can hear me. I appreciate the opportunity to speak to you today. This is the story, as Elizabeth indicated, of two men, Harry S. Truman and Robert H. Jackson, whom you see here in the Oval Office, the White House. These two men worked together to bring to justice the surviving leaders of Nazi Germany, men who had committed unspeakable crimes during the Second World War. In doing this, Truman and Jackson helped establish principles of international law that are still recognized to this day. Truman and Jackson were different in many ways, but they did have some things in common. Both of them came from relatively humble backgrounds. Truman's early years were spent on a farm near Kansas City, Missouri. Robert Jackson was born in a farmhouse in Spring Creek, Pennsylvania. Both men were ardent and lifelong members of the Democratic Party. Neither of them graduated from college. Truman was the last American president to have that distinction, while Jackson would become the last person to date to reach the U.S. Supreme Court without the benefit of a law degree. I should note, however, that both of them briefly attended law school. Truman was a night student, part-time student at the Kansas City School of Law during the 1920s, and he stayed for a couple of years but had to drop out because of other demands on his time. Jackson, I understand, received a certificate from Albany Law School after a year of study, but he wasn't awarded a degree because he was at that time under the age of 21. Both Truman and Jackson really rose to prominence in the 1920s. Truman as the chief administrator of his county's government, and Jackson as a successful lawyer in Jamestown, New York. During the 1930s, both Truman and Jackson came to Washington, D.C., and they were both in the capacity as supporters of President Franklin D. Roosevelt's New Deal. Senator Harry Truman, whom you see here in this autographed photo, was elected to the United States Senate from Missouri in 1934 and re-elected in 1940. On April 14th, 1943, Senator Harry Truman addressed a rally held in Chicago, Illinois, in behalf of the oppressed and persecuted Jewish people of Europe. I think I clicked on the wrong button there. I'm sorry. Okay, I'm okay now, I think. This is some of what Truman said in that speech in April of, take note of the date, April 1943. And I quote, "In conquered Europe, we find a once free people enslaved, crushed, and brutalized by the most depraved tyrants of all time. Through the edict of a mad Hitler and a degenerate Mussolini, the people of that ancient race, the Jews, are being herded like animals into the ghettos, the concentration camps, and the wastelands of Europe. The men, the women, and the children of this honored people are being starved, yes, actually murdered by the fiendish Huns and fascists. Today, these oppressed people, still with spirit unbroken, look for succor to us, we people of the United States, whose flag has always stood for liberty, freedom, and justice for all." No one can any longer doubt the horrible intentions of the Nazi beasts, he went on to say. We know that they planned the systematic slaughter throughout all of Europe, not only of the Jews, but of vast numbers of other innocent peoples. The streets of Europe, running with the blood of the massacred, are stark proof of the insatiable thirst of the Nazi hordes. So it's very clear from this speech that Truman was aware of much of what was going on in German-occupied Europe. By April of 1943, when he delivered that speech, many hundreds of thousands of Jews and other so-called enemies of the Reich had already been murdered at the major Nazi extermination camps in occupied Poland, Auschwitz, Majdanek, Belzec, Sobibor, and Treblinka. By the end of the war, this death toll would rise into the millions. In Germany itself, conditions in the SS concentration camps were rapidly deteriorating. Now, the distinction is not a perfect one, but in contrast to the extermination camps, most prisoners in the Nazi concentration camps were not killed as soon as they arrived. Instead, many of them were systematically worked to death or allowed to die slowly from disease or starvation. You can see these hospitals, so-called hospital cribs in Buchenwald, one of the Nazi camps. And the hospitals basically, at some point, if not very early on in the war, certainly had become little more than places where the sick were left to die. One of these camps was Buchenwald, and approximately 56,000 prisoners perished in that camp before the end of the war. General Dwight D. Eisenhower, the supreme commander of Allied forces in Europe, inspected one of the camps soon after it was liberated. He was thoroughly disgusted by what he saw and is said to have remarked that he was ashamed that his last name was Eisenhower, an allusion to his own ancestry. A few months after the surrender of Germany in July of 1945, Harry S. Truman, who had become president upon Roosevelt's death in April, traveled to Potsdam in Germany to meet with Joseph Stalin and Winston Churchill. The Allies by this time had already agreed to put the major Nazi leaders on trial instead of summarily executing them. as some had advocated. In this photograph, you see Stalin with his cigarette in his mouth and Truman and Churchill. We actually have in our museum collection here at the Truman Library a package of Stalin's cigarettes from Potsdam, supposedly swiped by a US GI. Although Truman looks a little guilty in this photograph, I'm not sure if he may have been the actual culprit, but in any event, we wound up with a package of the cigarettes that Stalin smoked at Potsdam. Truman at Potsdam found that he liked Stalin, which Churchill certainly did not, and he was eager to work with him as much as he could in cooperating during the post-war world as they had cooperated during the war as allies. Here is Justice Robert H. Jackson. I'm sure you recognize him. He also came to Washington during the early years of the New Deal. His ascent in government was very rapid. After serving as an attorney first in the Treasury Department and then in the Justice Department, he was named Solicitor General of the United States in 1938. In 1940, he became Attorney General of the United States. In June of 1941, President Roosevelt appointed him to the U.S. Supreme Court. Roosevelt, New Yorker. He had earlier encouraged and had even mentioned Jackson as a possible. Observers had expected that Roosevelt would name Jackson Chief Justice in 1941 when Charles Evans Hughes retired from that position. For various reasons, the president instead promoted Associate Justice Harlan Fiske Stone to the Chief Justiceship and made Jackson an Associate Justice. But he also indicated to Jackson that he would be considered for elevation to Chief Justice when the elderly Stone retired from the bench. As Supreme Court Justice, Jackson was known for the eloquence of his written opinions. His opinion in West Virginia Board of Education versus Barnett in 1943 is especially famous. In this case, Jackson spoke for the Supreme Court in striking down a state law in West Virginia that had required public school children to pledge allegiance to the flag. This was a law that had been passed during the war, during a time of great patriotic fervor, but it was challenged in court by the parents of children who were members of the Jehovah's Witnesses. In his decision, in his opinion, Jackson made this memorable statement, which is much quoted. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. These words are significant because Jackson would soon find himself prosecuting a regime, the members of a regime who had indeed sought with terrible consequences to impose an orthodoxy in politics, nationalism, and religion. Within a few weeks of taking office in April 1945, President Truman decided that he wanted Robert H. Jackson, the Supreme Court Justice, to serve as U.S. Chief of Counsel at the upcoming war crimes trial. In this letter to the President, dated April 29, 1945, Jackson accepted the post, even though he was, by his own admission, very reluctant to take an extended leave of absence from the Supreme Court. Jackson writes, in fact, I have decided that I can undertake the work, which I consider a grave responsibility, but I will do so if my general ideas of handling the matter meet your approval, which in fact they did. And on May 2nd, 1945, President Truman made Jackson's appointment official with this executive order 9547, which he signed on May 2nd. Truman assured Jackson that he would not have to resign from the Supreme Court. He did, by his authority as President of the United States, designate Robert H. Jackson as Chief of Counsel, and that he would, and stated that he would preside or participate in the trial to be held the International Military Tribunal, as it came to be called, serving without additional compensation, but receiving allowance for expenses as may be authorized by the president. Now, Robert Jackson hoped that this war crimes trial could be finished in a few months, perhaps even before the Supreme Court's next term began in October 1945. As it turned out, the proceedings would not be concluded until October 1946. As soon as the Supreme Court's term ended in June 1945, Jackson traveled to London to confer with representatives of the other Allied powers, the United Kingdom, the Soviet Union, and France. Jackson insisted at the conference that the trial of the major war criminals be held in Nuremberg, in the American zone of occupation. Nuremberg had been devastated by Allied bombing during the war, but its jail, seen here in a distance, and its imposing palace of justice were still intact and could be prepared by the army for the proceedings. Soviet representatives had wanted the trial to be held in Berlin, but they finally gave in on this point. At the London conference, the Allies agreed to establish the International Military Tribunal, IMT, with prosecutors and judges from each of the four nations. In early October of 1945, 24 leaders of Nazi Germany were formally indicted. They were indicted on 4 counts: conspiracy to commit the crimes listed in counts 2, 3, and 4, crimes against peace, war crimes, and the final and perhaps most significant one, crimes against humanity. These were new concepts now being presented, fairly new concepts anyway, now being formalized in international law in this indictment. Some of the defendants were charged on all 4 counts, others on selected counts. The prisoners at Nuremberg in the jail were kept in cells that, as you can see, were closely monitored guards. Despite this precaution, 2 of the accused were able to commit suicide. Robert Ley, former head of the German Labor Front under the Nazi regime, strangled himself in his cell in late October 1945. The other, more famous suicide would occur after the trial was over. One of Jackson's assistants at the Nuremberg trial was Catherine Fite, later Catherine Fite Lincoln, which is her married name. She was a remarkable person. She had graduated from Yale Law School in 1930, during a period when few American women entered the legal profession, and indeed some law schools still barred women from attending. While serving as assistant to the legal advisor in the State Department, she was assigned to temporary duty in Nuremberg with the Chief of Counsel's office. And you see her here with Robert Jackson, a photograph from her collection of papers that is autographed, as you can see, by Justice Jackson. The Harry S. Truman Library has a collection of Catherine Fite Lincoln's papers, which include letters she wrote to her parents while she was serving in Nuremberg. The letters have been digitized and are accessible on the Truman Library's website. Here is a quotation from one of her letters, and the defendants. There they are, all in the box. A seedy-looking lot, Goering in a light gray uniform, putting on a very debonair act, leaning over, chatting with his counsel, then turning and laughing with Raeder behind him, Admiral Karl Raeder. Rudolf Hess, stares vacantly into space, which he would do for much of the trial. My friend Frick, Wilhelm Frick, looks pretty evil, but calmer than yesterday. I saw him watching me. He probably hates me and my prying ways. Ribbentrop looks like a sick cat. It hurts his vanity. Joachim von Ribbentrop, the former Nazi foreign minister. And she wrote a number of letters that are very interesting to her parents describing the events at the trial. This one written on November 20, 1945, about a month after the tribunal had begun its proceedings. And the trial continued into December. The collection of Catherine's papers includes this photograph of a Christmas party that was held at Justice Jackson's residence in Nuremberg in December 1945. You see that Jackson has autographed it right under his own image here in the photograph in front of the Christmas tree. And this was probably a welcome relief for the people who were stuck at Nuremberg dealing with this very grim business under very difficult circumstances far from home. Robert Jackson headed a team of lawyers, prosecutors at Nuremberg, a very distinguished team that you will notice included some notable names, including General Telford Taylor and a future United States Senator, Thomas Dodd. More about him later. The British prosecutors were headed by Sir Harley Shawcross, and there were others working under him. Soviet prosecutors led by General Rudenko. The French prosecutors were also involved, and they had some difficulty because in European law, the concept of a conspiracy to commit a crime was somewhat alien to their traditions, but Jackson was able to persuade the tribunal that an indictment on the basis of conspiracy should be allowed. This is a diagram of the courtroom in the Palace of Justice at Nuremberg. The 8 judges, 1 judge and 1 alternate from each of the 4 allied nations were seated, as you see here, on the right side of the courtroom. The prisoner's dock was directly across from them, and the prosecutor's tables were in front of the areas reserved for the press and for VIPs or distinguished visitors. The eyes of the reporters and other spectators during the trial were often drawn to the prisoner's dock, in which sit 20-odd broken men, as Jackson said in his opening statement to the tribunal. And here you see them in the dock with the guards, white helmeted guards behind them, the translators and other staff in front of them. This is the counsel table for the Americans. You see Justice Jackson and his fellow attorneys there. This is the Soviet delegation, which was notable in that they were attired in very conspicuously in military uniforms. As in any trial, this one featured a presentation of many exhibits, as well as documentary evidence. Among the exhibits was this diagram of the Nazi system of concentration camps. On November 21st, 1945, Justice Robert H. Jackson, as you see here in this photograph, rose to deliver the opening statement for the United States at the International Military Tribunal. He delivered a powerful speech summing up the purpose and significance of the trial. And here is a famous excerpt, the beginning of his statement. The privilege of opening the first trial in history for crimes against the peace of the world imposes a grave responsibility. The wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. That 4 great nations, flushed with victory and stung with injury, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason. Jackson's opening statement received widespread acclaim, but only a few months later, his cross-examination of Reichsmarshal Hermann Goering, who you see here, the senior Nazi leader in the prisoner's dock, proved to be extremely controversial. Freed of his morphine addiction and forced to lose a great deal of weight while he was in prison, Goering had regained much of his native cunning as well as his imperious attitude. He knew the facts of what had happened in Germany better than anybody in the tribunal, and he used this firsthand knowledge often to lecture the tribunal during his testimony. Jackson, during his cross-examination, realized that Goering was really speaking over the heads of the tribunal. This was something Jackson was very concerned about. Goering was being given an opportunity to speak to the German people and to posterity. And during his cross-examination of Goering, Jackson became visibly frustrated when the tribunal allowed the Reichsmarshal to make long statements from the witness stand instead of directly and succinctly answering his pointed questions. The judges concluded that the defendant should be allowed that privilege of which he took advantage. At one point, in exasperation, Jackson stated to the tribunal regarding Goering, this is on March 18, 1946, "This witness, it seems to me, is adopting and has adopted in the witness box and in the dock an arrogant and contemptuous attitude toward the tribunal, which is giving him the trial, which he never gave a living soul, nor dead ones either." However, the tribunal ruled that Goering would be afforded great latitude in responding to questions. Despite the problems with cross-examining Goering, it took a while, but Jackson did succeed in pinning him down on a lot of points. And indeed, the tribunal saw many documents which the prosecution was able to marshal, if you'll pardon the expression, very convincing evidence in these documents against Reichsmarshal Goering. This is one of those pieces of evidence, translation of a message, July 1941, from Goering to Reinhard Heydrich of the SS, which includes authorization to solve the Jewish question and achieve, again, using this euphemism, a final solution of the Jewish question by immigration and evacuation. Well, this was basically a code word for evacuating Jewish people from Poland and elsewhere in Europe on trains to Auschwitz and other camps where they were, many of them, most of them, in fact, were murdered shortly after their arrival. And this was evidence that mounted steadily during the course of the trial in spite of Goering's attempts to dodge the issue or rationalize the issue during his testimony. On April 24th, 1946, a month after his confrontation with Goering, Robert H. Jackson wrote this letter to President Truman. It is Truman's papers here at the library. In the letter, he criticized Judge Francis Biddle, the chief American judge at the tribunal, saying, "I had hoped that Mr. Biddle, in view of his experience in government, would sense the situation and assert his influence in the direction of a strong control by the tribunal of such witnesses as Goering and Alfred Rosenberg. In this, I have been disappointed. Early in my cross-examination, when I tried to get from Goering a yes or no answer, the Lord Justice, that was Geoffrey Lawrence of Great Britain, at Biddle's prompting, without any objection by Goering's counsel, informed him that he could make any explanation he desired in connection with his answer. The result was a series of irrelevant speeches full of professions of patriotism and martyrdom, which the Allied Control Council fear aroused sympathy for him. And he generally ran over us in a way that gave a bad impression of our own capacity to deal with him." So it was very clear that Jackson felt that Biddle, in particular, whom he had known for many years, had let him down through this ruling. However, he adds that by their long harangues, Goering, Ribbentrop, and Rosenberg have been compelled to admit the authenticity of every single document which incriminates them. He goes on to refer with obvious regret to his long absence from the Supreme Court, which had gone on far longer than he had expected. "I suppose I am unduly sensitive about these delays because I have been away from home nearly a year, and thy absence from the causes criticism of you as well as of me. Now you have additional complications due to the death of the Chief Justice, which leaves only a 7-man court and may disable it from deciding some further cases. So he indicates in this paragraph that he's willing to come back temporarily from Nuremberg and resume sitting on the court if necessary. Truman decided that that would not be necessary. And in the next to the last paragraph, later he expresses his appreciation for Truman's compliments about his performance. But in the next to last paragraph, he says, by the way, I would like to mention a young man borrowed from Tom Clark, the Attorney General, who has done, future Attorney General, who has done extremely creditable work here. He is Tom Dodd, Assistant United States Attorney in Connecticut, who I am told is being looked upon favorably by the Democratic leaders of his state. He has done such excellent work that I should have put him in charge in my absence had I been returning to the States. And I think you are apt to hear of him in the future. Well, indeed, that was true, because Thomas Dodd would later become a United States Senator from Connecticut. His son, Christopher Dodd, would later become his successor in the United States Senate from Connecticut. And Christopher Dodd published a collection of the letters that Thomas Dodd had written to his wife from Nuremberg. In these letters, however, somewhat ironically, Dodd was very critical of Robert Jackson's performance in cross-examining witnesses. In this transcript of this letter, which you see here, I thought, too, that Speer would be easy, referring to Albert Speer, the armaments leader, and Jackson would look good in questioning him, in other words. Well, Jackson, made a mess of it. That is, he did not do it all well. He just cannot cross-examine. Of that I am completely convinced. When the Goering case went so poorly, I felt that Biddle had made Jackson's task very difficult, that Goering was himself a very difficult man to examine, that perhaps the justice had a bad day, that on the record it wasn't bad as it sounded. With Hjalmar Schacht, another defendant, we had a fairly weak case, and Jackson was nervous because of his Goering situation, and that all in all, it wasn't too bad. But after yesterday, I know now that the justice simply does not have the ability to cross-examine. It shocks me that he doesn't know it himself. He could have avoided all this by staying out of it entirely and by exercising only the duties of chief counsel in a case of this size. Speer was ripe for plucking, but it didn't work out. Of course, he will not escape. We have far too much on him, but we could have destroyed him as he really deserved. Well, that was Dodd's assessment. Now, Jackson was an experienced trial attorney. That was just kind of Dodd's opinion, but it was shared by other people. Dodd was especially, as you can see, concerned that they had somehow not done their best effort against Albert Speer, the crafty armaments chief who had served under Adolf Hitler. Speer ultimately was convicted, but he received a somewhat comparatively light prison sentence compared to the other defendants. So Dodd had some regrets about that. We don't know. I can't really know how valid his criticisms were, but they were made by others as well. In the midst of his exhausting ordeal at Nuremberg, Jackson became embroiled in a public controversy involving a fellow justice of the Supreme Court, Hugo Black. Like Jackson and like almost everyone else in the court, Black was a New Dealer who had been appointed by Franklin Roosevelt. But Hugo Black over here had a temperamental nature. He is to the right of Chief Justice Vinson in this 1946 photograph to Vinson's right. He had a temperamental nature, which was reflected in his nickname, Hugo to Hell. In June 1945, shortly before Jackson left for Europe, Black and Jackson, who was standing just behind the Chief Justice's left shoulder, became involved in a heated argument in the court's conference room. Black had failed to disqualify himself from ruling in the Jewel Ridge labor case, a case in which his former law partner was one of the attorneys, and Jackson regarded this as highly unethical on Black's part. And he was further angered when Black then cast the deciding vote in that labor case. Rumors of the conflict soon reached the ears of various journalists, and after Chief Justice Harlan Stone died the following April 1946, it was reported that both Black and Jackson had threatened to resign from the Supreme Court if the other was promoted to Chief Justice. We don't know, can't be really sure if those rumors were true, but there was certainly some animosity there. In June 1946, President Truman moved outside the court and select someone who wouldn't be involved in some of this animosity, nominated his friend Fred M. Vinson, a veteran politician, for the post of Chief Justice, and that's Chief Justice Vinson in the middle there. A few days later, an angry Robert H. Jackson sent a public message from Nuremberg to the President and the Congress. By the way, you see that the Chief Supreme Court Justices, including Jackson, have all autographed this particular photograph. Jackson sent this message to the President and to the House and Senate Judiciary Committees of the Congress. In the message, he endorsed the nomination of Fred Vinson, but he also took the opportunity to discuss in rather angry terms his disagreement with Justice Black. He made it really public, although it had already been publicized to some extent before. Among other things, he stated in this cablegram from Nuremberg in June 1946, referring to the practice of Supreme Court judges participating in cases in which their former law partners were arguing. Jackson wrote, and this is based on principle, not personality, "I wanted that practice stopped. If it is ever repeated while I am on the bench, I will make my Jewel Ridge opinion look like a letter for recommendation by comparison." So this was a rather angry message. And it must be kept in mind that Jackson was under a lot of pressure at this time. He'd been away from home for a long time, and it must have been difficult for him to be confronted by these circumstances, including possibly the realization that he was not likely to ever become Chief Justice of the United States as he may have hoped. But in any event, this was one of the things that occurred during his long service in Germany during the IMT trial. On July 26, 1946, a month after this cablegram, Robert Jackson delivered his closing statement at the Nuremberg trial. As he had in his opening statement 8 months earlier, he addressed the tribunal with solemn eloquence, concluding with this well-known statement: "If you were to say of these men that they are not guilty, it would be as true to say that there has been no war, there are no slain, there has been no crime." The International Military Tribunal handed down its verdicts on October 1st, 1946. 12 defendants were sentenced to death by hanging. One of those defendants was Martin Bormann, and he had been tried in absentia because he had not been captured by the Allies. Bormann, along with 11 others, received the death sentence. Many years later, as you probably know, it was confirmed through medical examination that Bormann had died during the Soviet assault on Berlin in May 1945, possibly a suicide. Hermann Goering, who was also sentenced to hang, as you probably know, was able to commit suicide with a capsule of cyanide the day before the sentence was carried out. 3 defendants were acquitted. The others received prison sentences of various lengths. Of the 24 persons named in the original indictment, 2 of them were never tried. One of them was Gustav Krupp, the armaments chief, who was very ill and elderly and was judged to be in too poor health to be tried, to participate in the trial. The other, of course, was the German Labor Front leader, Robert Ley, who committed suicide early in the trial. So these are the verdicts, basically 19 convictions out of the 22 who were actually tried. And you can see the expression on Jackson's face as he comes down the ramp from the plane getting back to the United States. After more than a year of service in Germany, he was finally able to return to the United States and resume his duties on the Supreme Court. It was noted that when he met with his fellow justices upon his return, Jackson and Hugo Black made it a point to shake hands and thereafter maintained a fairly amicable relationship in spite of their past differences. And I think that speaks well of both of them. On October 7th, 1946, 6 days after the verdicts were handed down at Nuremberg, Justice Jackson sent this letter to the president, in which he summarized the Nuremberg trial, which he regarded as basically successful, and also mentioned the great effort that had been made in carrying out this tribunal. At the conclusion of his letter, he writes, "I hereby resign my commission as your representative and chief of counsel for the United States. And I am consoled by the fact that in proceedings of this novelty, errors and missteps may also be instructive to the future." And I think that was true as well. But principles and ideals were established at this tribunal, thanks in part to Robert Jackson, that continue to affect the way the world at large, the international community, views the morality of actions by governments, internally or in the international realm. This is a bust of Jackson that is in our collection here at the library. Robert H. Jackson served on the Supreme Court for a decade, almost a decade after he came back from Nuremberg. He was able to participate in the landmark Brown versus Board of Education Topeka decision in 1954, joining the majority unanimous court, really, in holding that public school segregation on the basis of race violated the U.S. Constitution. Soon thereafter, on October 9th, 1954, Robert H. Jackson died of a heart attack in Washington, D.C. At his funeral in Jamestown, New York, the other 8 members of the Supreme Court, Hugo Black among them, served as his honorary pallbearers. Thank you very much, and I would be very glad to answer any questions if you have any.
Thank you so much, Randy. Does
Oh,
anyone,
hi, you can hear me, good.
I was just looking in the chat here. Does anybody have any questions that they'd like to ask? I also loved the picture you showed of Jackson getting off of the plane.
Yes.
We have so many pictures of Jackson where he looks so stern. So to see a picture of him smiling always makes me happy.
I think there might have been a question about the personal relationship between Jackson and Truman. Yeah.
Yeah. Mm-hmm.
Yeah. I don't think they were fairly close. I think Truman admired Jackson, thought very highly of him. At one point, according to one account, he mentioned to Clark Clifford that this was an individual who, although he was on the Supreme Court, he might be a possible successor as president in the future. And I think his support for Jackson continued throughout the trial. He did say during the controversy, the feud when that became public between Black and Jackson, I think he said, "Well, the Supreme Court seems to have messed everything up," or words to that effect. But he was just trying to maintain as much harmony as he could on the court. I don't think he held Jackson to blame for that.
We have, how was Truman convinced to hold a trial rather than a summary execution? Kind of what made him decide that, rather than kind of
Well, I think that was his,
otherwise?
yeah, I think that was his preference. Yeah, I think that was his preference from the beginning, but that was more or less decided upon. I guess Stalin may have made some remark about why don't we just shoot them all, or words to that effect. And Churchill said something that he wouldn't stand for that. I'm not sure, but I think the tendency pretty much all along was that rather than have a summary execution, there should be some kind of formal proceeding to indicate why, if these people deserved to be executed, why they should deserve that and what they had done to deserve those sentences. And this seems to have been prevalent among everybody pretty much at the London conference anyway, among the Allies. But there was some opposition to that. People who thought it was pretty much of a trial, a victor's justice trial. And I can understand that point of view too.
Yeah, I think the ball was rolling on that a little bit, at least before Roosevelt even passed away. The idea of
That's
doing trial.
probably true.
Yeah.
Mhm.
What was Truman's biggest takeaway post Nuremberg?
What did he bring from that experience? Well, I think he was satisfied that uh, justice had been dealt to uh, people who deserved punishment. And he was satisfied also that the process of trying war criminals could continue because there are two phases to the Nuremberg trials. There's the International Military Tribunal, the subject of the recent movie, and of the major war criminals. And then there were the subsequent proceedings at Nuremberg in which the United States tried lower level officials, doctors who had participated in horrific experiments and other practices in the camps, um, members of the armed forces who had committed war crimes. Uh, these trials went on for several years thereafter. One of those trials is the subject of the somewhat fictionalized movie Judgment at Nuremberg with Spencer Tracy, which
Mhm.
was released in 1961. Um, and as that movie indicates, by that time, people were beginning to get tired of it, and there was some concern about alienating public opinion in Germany by continuing to try these people at a time when tensions between the United States and the Soviet Union had grown, and the position of West Germany and West Berlin as part of the Western Alliance had become more important. Anyway, I think Truman was basically satisfied with the results of the war crimes trials and that they had established certain principles. It's clear from that speech he made in 1943 that this was something that appalled him and that he felt required some direct action by the Allies after the war.
And did he have any kind of feelings directly on how Jackson's work at Nuremberg went?
Well, I think, as far as I know, he approved of it and was willing to take some heat for having him off the court for that long and for the possible delays in some cases. I don't think there was any major disruption in the workload, although a lot of the members of the court were angry about it a little bit, miffed by it. They had to write more opinions. There were maybe some cases that might have been deadlocked and had to be retried. I think Truman was willing to uh, accept that as a price of having Jackson as a prosecutor, and he did not feel that Jackson should have to resign from the Supreme Court in order to fulfill this function. There were others on the court, such as Justice Frankfurter, maybe Chief Justice Stone, felt that it was inappropriate for a member of the court to take an executive responsibility. Jackson didn't agree, and neither did Truman.
I'm just going to kind of, because this one kind of ties directly into that. Somebody asked, what, in your opinion, may have been the largest impact of his absence from the court?
Well, I think it accentuated some of the tensions that already existed on the court, some of which were ideological, having to do with different views regarding judicial self-restraint, in the idea of Felix Frankfurter and Hugo Black, who tended to favor more judicial activism. In other words, people who didn't think that the court should strike down, in most cases, in many cases, state laws or federal laws just because they didn't like them. They ought to defer to the wisdom of the people's elected representatives because judges aren't elected. Supreme Court judges are not elected by the people. So you should defer to the elected representatives. And then there's the contrasting view of Hugo Black, that there was a responsibility on the part of the judiciary to act vigorously in striking down laws that are unconstitutional. There's a difference in philosophy there. The Black Frankfurter feud was not personal really so much as it was ideological. Jackson tended to be more on the side, I guess, of Frankfurter than Black on many of those issues. However, his absence did, as I say, accentuate those tensions. The justices were grumbling. The whole situation about Chief Justice Stone dying and that position being open and somebody being appointed to replace him, I think that interjected some more venom into the into the court. And Black and Jackson obviously became jealous of each other to a greater extent, having heard what the others supposedly said, whether they did or not. It really did help to bring the court into a certain amount of disrepute and public, um, uh, not scorn, but public doubt, because the Supreme Court always tries to maintain an image of unanimity, or at least of cordiality, and its disputes that are internal are, as much as possible, kept out of public life. That's why Robert Bob Woodward's book, The Brethren, was so shocking when it was published, because he revealed a lot of secrets about that period of the Supreme Court, a lot of the conflicts that existed, and people were shocked by that. Well, judges are human beings, and they have some of the same animosities and vanity and
And I think
vices that
there's
others
always kind
have.
of been this,
Yeah,
I think there's always kind of been this belief that the court is apolitical, which is not true.
no, it can't be really, but they do want to try to maintain that sense anyway, and it did have that effect. I don't think it was a lasting effect. And I might say that under Chief Justice Vinson, whom Truman appointed to try to restore cordiality to the court, we may have done that, but the tensions and differences still existed, even under his service as Chief Justice.
Mm.
And it it continued uh, into the early 1950s uh, when uh, Chief Justice Vinson died, supposedly before the Brown versus Board of Education case was decided. Felix Frankfurter supposedly said that his death was the only example he had ever seen of the convincing evidence of the existence of God, because he was afraid, as others were, that Vinson, who was from Kentucky, would somehow sabotage the ruling of the Supreme Court that against school segregation. I don't know if that's an apocryphal story or not, but it does reflect some of the tensions that existed on the court even under Chief Justice Vinson, a man for whom Felix Frankfurter did not have much respect. But then again, Felix Frankfurter didn't have a lot of respect for a lot of people. He was a very imperious individual with a very formidable intellect, and he rubbed a lot of people the wrong way.
Mhm. Somebody asked, I've often wondered how the evidence for the trials could be compiled so quickly at the end of the war. From where was the majority of the evidence obtained, and were there difficulties in obtaining what could be sufficient evidence?
Well, I'm not an expert on that. I believe that they captured a lot of German records intact, although the Germans weren't able to destroy as much of it as they might have. And the Germans had been very meticulous record keepers. They even kept records of the figures from the statistics from the concentration and extermination camps, which you would think they wouldn't have kept, but they did. They kept records of the train transports when they arrived, etc. They kept records of the atrocities. They kept records of all of the machinations of the leaders of the government, which led to this state of affairs during World War II. And basically, they used the records of the German Nazi regime against its leaders. They had a substantial and voluminous body of records to use, and just the size of it, of the evidence, was so extensive. That was one of the biggest problems. They had to find the materials, translate them into different languages, and decide which of the documents was most telling in in the presentation of evidence at the tribunal. But I'm not really an expert on that, but there were obviously hundreds of people involved in that process during the course of the trial.
Yeah, I'll just mention that this summer we're doing a movie series here at the Jackson Center. If you're local to Jamestown, if you'll be in the area, we're going to be showing a movie called Filmmakers for the Prosecution, where they talk a lot about how they Army sent out people to collect a lot of the evidence,
Yeah.
and specifically there were Hollywood ties to some of the people who went out and collected a lot of the evidence. So it's a very interesting story. One of the other questions we have is, do others agree that Jackson was a poor cross-examiner?
I don't know. I think it just the criticisms that have made of his performance against Goering. I suppose you could say that. I really it seems to me he was a very experienced trial attorney. I will admit that as Solicitor General, he was not. He was arguing before the court. He wasn't questioning witnesses, and he was known as a masterful Solicitor General, maybe the best ever. He was so good in those oral arguments to the court, and the statements that he made at Nuremberg are very memorable and very persuasive. But he hadn't been cross-examining people in a long time, and frankly, I think the tribunal, for the sake of fairness, allowed a lot of latitude to the defendants, particularly Goering, who could talk on and on and on about all these details and say smart aleck things and so on and make wisecracks. And at one point, Jackson said, "Well, these plans for mobilization, they were kept secret, weren't they?" And Goering said, "I don't recall reading the American plans for mobilization in the newspapers." And that really, Jackson really got mad when he said that, which was true, but you're comparing very different situations. The United States wasn't getting ready to invade and conquer other nations. But yeah, he maybe got flustered and frustrated, but his defenders would argue that he was able to elicit the admissions that he needed to convince the court that Goering and the others were guilty. It may not have been Perry Mason style cross-examination, but that's kind of fictional anyway. I can't really evaluate that, not being a lawyer. But it's not as though Jackson had no experience as a trial lawyer. He had a lot of experience. It's just that it had been some time since 1934 when he came into government. He really, well, there's some exceptions there, but since he became Solicitor General in 1938, he really hadn't had those kinds of experiences, and that may have been part of it. But I think there are some who, at the time, who criticized him, and even Francis Biddle, told him, "Well, you just weren't at your best," supposedly. Well, maybe that's true, but I'm not sure that's a universal point of view. It was Dodd's opinion, obviously.
I think also part of the challenge was, I mean, we think of the American court system where when, we take the stand, we swear an oath and we face perjury charges for lying, and that's not a thing in European courts, and it was not a
Uh-huh.
thing at the IMT. So, when they were
I
on the
see.
witness stand,
I
the
see. I didn't
defendants
know that.
were,
Okay.
yeah, they're allowed to basically say whatever they want. And they're allowed to talk for as long as they want, and they're allowed to basically
Very
justify.
different legal system. Yeah.
Exactly.
Yeah.
And I think that was something that really flustered Jackson. It's something that he was, he's like, he's
Mhm.
lying. And the tribunal's like, well, he's allowed to.
I think he personally detested Goering, and it was difficult for him to keep that feeling in to himself. And also, I think that dealing with different legal systems, four different legal systems trying to adapt to each other, and the French not having this concept of conspiracy to the same extent, for example, the traditions are different. And so maybe that was inevitable.
So here's another question. Were there questions by Truman or other U.S. officials about possible ex post facto aspects of law to be applied by the tribunal?
I'm sorry, what was that? Uh,
Were there
Possible.
questions by Truman or other U.S. officials about possible ex post facto aspects of the law to be applied by the tribunal?
I don't, not that I know of, not that I know of. They felt that these were basic principles of long recognized international law, and that uh, this was a concern raised by a lot of critics of the Nuremberg trials. I don't think Truman and his administration, people involved in this, Judge Rosenman, who was his at that time counsel to the president, I don't think that was something that they thought was relevant. They felt that these were people who were guilty of terrible acts, and um, whatever value their opinion was, they felt that it was not an issue, that these were in effect kind of applying ex post facto principles. Um,
Um,
it's
we
in the
have
nature of the people who won the war are putting people on trial.
Right. We have one
And
other
that is
question.
one of the reasons that criticism has been made.
We have one other question. Is there evidence that Jackson and Truman ever paused to compare the mass civilian casualties that happened during air attacks to the prosecution that they were conducting?
No, I don't think they ever brought that up. It may have been mentioned, I don't know, by the German defendants that you're accusing us of killing a lot of people. Well, look at all the hundreds of thousands of civilians who were killed in the Allied bombing of Germany and other parts of Europe and Japan, including the atomic bombs. Aren't those war crimes? Well, they're terrible acts, but I think that the argument that people would make in response was this was incidental to attempts to destroy the enemy's industrial base, their weapons of destruction, their factories, and so on. And it was unavoidable that civilians would be killed. I don't know how valid that statement is, but that would be the defense that was offered. And what the Germans or the Nazis had done was systematic murder, hundreds of thousands of people, basically just to get them out of the way because they regarded them as racially inferior and inherently. I mean, this Nazi racial madness was just infected the whole SS. The people who administered these camps, they didn't regard these people as human beings. They really didn't. And with a few exceptions, they treated them like they were subhumans, and it was of no concern to them. That's a different order of evil than bombing, than the killing from bombing, terrible as it is. That would have been the response anyway.
Yeah, I think you're right. Well, thank you everyone for joining us today, and thank you so much, Randy, for your presentation.
Thank you. You're welcome.
I hope everyone will join us for our next program in the symposium. It takes place on Friday, February 6th, also at 12 o'clock Eastern. And this one will be done by our friends Courtroom 600 out of Chicago. And it is called Images of Hate, Trials of Conscience, what Nuremberg taught us about propaganda, perpetrators, and the law. So I just dropped the link for that in the chat. If you haven't registered for it yet, feel free to do that. And we hope we'll see you all again next time.